Breaking news, at Kampung Beluka Changlun in Kubang Pasu, one boy died and two were seriously injured after a pile of electric poles crashed into the three children. It was reported that the three were playing nearby when the incident happened. Superintendent Rodzi Abu Hassan from Kubang Pasu OCPD shared some crucial information regarding the children's recent status.
Kedah Operations Centre received a call regarding an incident involving electrical poles falling on a child, and it is believed all three victims were playing and climbing to the top of the pile, but the poles suddenly came crashing down and rolled over the boys. When our team arrived, all the victims had already been rescued by the public using an excavator, and two of the victims were found unconscious and were immediately taken to the Jitra hospital, while the dead boy's body was handed over to the police for further action.
We turn to Senior Deputy Commissioner Sayani Saidon from the Kedah Fire and Rescue Department for his comment on the incident.
All victims were between 10 and 11 years old. The boy died of serious head injuries and was taken to the Sultanah Bahia Hospital in Alor for a post-mortem, while the other two victims who sustained injuries to the thigh and hip were taken to the Jitra Hospital for treatment.
Some peace tonight in the arms of the angel. Fly away from here, from this dark, cold hotel room and the endlessness that you fear. You are of your silent reverie. You're in the arms of the angel. May you find some comfort here.
The young boy, a resident of Kampung Beluka Changlun, was the eldest child of a single father, Lepe, who works as a farmer. The boy, who is referred to as Boo by his loved ones, excelled in curricular and extracurricular school activities at Sekolah Kebangsaan Taman Mesra. His father expresses grief and sorrow towards losing his child, adding on to the weight of supporting 5 other children. If anybody wishes to lend a helping hand, please contact us to arrange a donation. As of now, the family has arranged a small tahlil to commemorate the loss of the beloved young boy. The family wishes to seek justice in the name of Bulat bin Lepir. While Malaysians pray for their children's safety, a lawyer has volunteered to take the case pro bono. We have a senior lawyer, Datuk Jaafar from Jaafar & Co.
So, this is a classic example of an occupier liability towards children. In this case, the owner of the construction site may be held liable towards the 3 boys. Yes, in fact, we have 2 landmark cases that can be applied here. The first case, British Railway Boards, and the second, Lembaga Elektrik Negara Malaysia. In the case of British Railways Board and Harrington, the fact of the case that the defendant owns an electrified rail line. There was a fence between it and a playground for children, but the fence had been in a run condition. Through the fence, people took a shortcut across the line. The defendant knew that some children also did the same, but they failed to repair the fence. The plaintiff, a boy who aged 6 years old, trespassed over the broken fence and was injured on the electrified rail. The judgment in this case, the occupier owes a trespasser a duty to take such steps as common sense or common humanity would dictate to exclude or run or otherwise within a reasonable and practicable limit, reduce or avoid danger. The court has to look at the lack of capacity of the trespasser, such as the inability of children to recognize the danger. If a fence marks a boundary, an adult who climbs over it will appreciate what he is doing. A small boy who finds a part of a fence so dilapidated that there is no real obstacle to his progress will not or may not know that he is at once a trespasser if he goes on. In this case that the occupier owes a trespasser a duty to take such steps as a common sense or common humanity would dictate, on the fact that the defendants will help to be in the breach of their duty to the charged trespasser. In another case, Lembaga Elektrik Negara Malaysia and Ramakrishnan, the fact of the case that the plaintiff, aged 10 years old, climbed up an hedge pole erected and maintained by the appellants in attempt to release a bird that was trapped on the wire of the pole. The boy was electrocuted as he reached the bracket which supported the cable box. He was thrown on the ground and suffered severe injury and first and second degree burns which resulted in scars and permanent disfiguring. The respondent trespassed on the property of the appellants. The claim was based on the negligence of the appellants in having erected and maintained the hedge pole which carried high voltage electric wires immediately adjoining an unfenced public footpath in a paddy field, in which the hedge pole and wires constitute a dangerous hazard and allurement to the respondent. The main contention before the High Court and the Federal Court was that the respondent was a trespasser and therefore the relationship of the occupier toward the trespasser fell into consideration. The judgment in this case that the appellant owed a duty to the respondent as they had erected, maintained and controlled a highly dangerous hedge pole of high detonator potentialities immediately adjacent to a footpath connecting to the kampung to the main road which was used by the kampung folk including the children. The pole was within easy reach of the children and it was ideally suited for children wishing to climb it. The appellant must be assumed to know that the children could be mischievous and could do things without realizing the consequences, and therefore there was substantial chance that they might come there. There was a duty because of the existence near to the public of the dangerous situation. Common sense and common humanity dictated that steps like putting up warning signs and adequate anti-climbing devices should be taken, but this was not be done. The decision by the court, the appellant will be held liable because they had erected a highly dangerous electric pole that was within reach of children and they failed to put up warning signs and adequate anti-climbing devices.
The duty of an occupier to a child licensee is higher when a child cannot be expected to be aware of dangers that may be obvious to adults. The duty of the occupier is not to lead children into temptation. In Latham and R. Johnson and Nephew Limited, Lord Justice Hamilton stated, "In the case of children, there are moral as well as physical traps. There may accordingly be a duty towards infants not merely to dig pitfalls for them, but not to lead them into temptation. Therefore, if there is an allurement to a child, the occupier can generally be assumed to be in breach of his duty. Parents cannot be expected to protect against a danger they cannot see, and this goes double where such dangers are not adequately signposted. Of course, not all minors are equal. Older children are less susceptible to harm than younger children. Thus, the relevant level of care will depend on the nature of the risk and the age and awareness of the child involved. Hence, there is no liability if there is no allurement. An object should not be considered as an allurement unless the temptation which it presents is such that no normal child could be expected to restrain himself from intermeddling, even if he knows that to intermeddle is wrong. As the defendant, he had a right to assume that prudent and reasonable parents or guardians would not allow their children to venture into open spaces without exercising any control or without first ensuring that the place was safe. However, it is also a must to observe that a reasonable parent would not permit their children to be sent into danger without protection, and the primary responsibility to ensure the safety of the children is upon the parents. The occupiers had a right to assume that reasonable parents would not allow their children to venture into open spaces without exercising any control or ensuring the safety of the premises. Justice Devlin once said, having decided that a licensor may have to take into account the social habits of the neighborhood, no doubt there are places where little children go to play unaccompanied. If the licensor knows or ought to anticipate that, he may have to take steps accordingly. but the responsibility for the safety of little children must rest primarily on the parents. It is their duty to see that such children are not allowed to wander about by themselves, or, at the least, to satisfy themselves that the places to which they do allow their children to go unaccompanied are safe for them to go. Any parent who looked could have seen the trench and taken steps to prevent his child from going there. Defendants were entitled to assume that parents would behave in this naturally prudent way. I conclude, therefore, that the infant plaintiff was on the land as a licensee, but there was no breach of the defendant's duty towards him. Section 2, subsection 3, paragraph A of the Occupiers Liability Act warns that children can be expected to be less careful than adults, and, by implication, that a greater level of care might be required to keep them from harm. The common law has sought to strike a balance between the responsibilities of parents and occupiers to prevent harm from befalling children.
In our current scene, based on the current issue arose at Kampung Beluka Changlun, Bukit Kayu Hitamnya Kubang Pasu, that involving the death of a boy and injuries to 2 other children, the main issue that must be stressed is the issue of the liability of the occupier that holds the duty of the electric poles at the said place of the incident. Therefore, the class of anchors must be first recognized in determining such liability. According to our current issue, we believe that the class of anchors in this case falls under the trespasser. A trespasser can be defined as one who voluntarily enters the premise without the right or without permission of the possessor, regardless of whether he is a playful child, a burglar, or a lost traveler. At present law, the court will be taken into consideration the owes a duty of care based on the principle of common humanity, which was first established in the common law case of British Railways Board and Harrington. Moreover, since the case involves the child, the duty of an occupier towards the child is higher, as the child cannot be expected to be aware of dangers that may seem obvious to adults. As the first landmark case was laid in British Railways Board and Harrington, it must be noted that an occupier owes a trespasser a duty to take such steps as common sense and or common humanity would dictate. And from the said case, the defendants were held liable due to their breach of duty to the child trespasser. Furthermore, we also rely on the principle from the decided case in our own country, which has a similar fact as the current issue, which was derived in Lembaga Literik Negara, Malaysia and Ramakrishnan. The judge in the aforementioned case has stated that the appellant must assume to know children could be mischievous and could do things without realizing the consequences. Thus, common sense and common humanity dictated that steps like putting up warning signs and adequate anti-climbing devices should be taken. From the 2 cases that have been mentioned, we believe that the same principle should be applied in our current scenario, as the facts are similar and related to one another, which is used as the supporting decided and referred case. In addition, in reliance on the provision governed under the Occupiers Liability Act 1957, under Section 2, Clause 3, Clause A, the provision warns that children can be expected to be less careful than adults, and, by implication, that a greater level of care might be required to keep them from harm. The common law has sought to strike a balance between the responsibilities of parents and occupiers to prevent harm from befalling children. All in all, according to the general principle adopted from the landmark case on a child trespasser, as well as the decision made in the local case, supported with the provision governed under the Occupiers Liability Act 1957, the court therefore should arrive at the judgment based on the occupiers' liability towards children in setting the possible claim towards the parties involved in this case.